Thank you everybody for joining us, and there are lots of people coming in as we speak. I'm Sam Clark, I'm from Learning Disability England. I'm really pleased to welcome you to today's session. I'm really grateful to Alex and Steve for doing another webinar with us. Everything we've done since lockdown started, really since mid-March, the thing we've had the most glowing feedback about was the last webinar they did with us. So I'm really excited about today's, and no pressure, of course, to you two. But lots and lots of people really valued it. So we asked them if they were up for having another session, because we were hearing from people with learning disabilities, family members, direct support staff, managers in organisations, a real new challenge about how to manage our new and evolving guidance around COVID-19, what it means, all kind of issues, much more nuanced, people felt, and were finding it difficult to think about how they were making decisions about what they did, about what others did. So we're really glad that they're doing this today, and that's what they're going to do. We will be finished by 4 o'clock at the latest. We might finish a bit sooner if you don't have loads of questions. That's fine. We can all go get a cup of tea or something. We are recording it, yeah, and some of us have got our drink with us. Will you, if you look at the bottom of your screen, you will see that there is a question and answer section. If you have questions that you want to ask about anything that Steve or Alex has said, like a clarification or something related to what they've said, then if you can put it in the question and answer bit, then whoever isn't speaking of the double act is going to try and keep an eye on those. If you've got any problems with technical stuff or anything like that, my colleague Rachel and I will be keeping an eye on the chat as well. But if you can use the question and answer bit, it allows us to track what's there. So I think that's everything. I'm gonna hand over to Alex. I believe he's first. Is that right, Alex?
Yes.
Right?
Yeah. So I'm going to go just to give you a kind of route map of what we're doing. How Steve and I thought we would play it is I'm going to do a kind of bit of an overview and just kind of give us in particular the ABC, the legal ABC. And then Steve has kind of agreed he's going to take some of the specifics, which were questions people had asked in advance. And then I think what we'll do is effectively tag team in terms of questions that people put up as things go along. We may, as Sam says, we may try and keep an eye on them and answer them in the chat function as we go along, but we may also, depending on time, do it as it were live. So as it were orally, as opposed to writing stuff down. So without further ado, I want to do this. Some of you may have logged on to the National Mental Capacity Forum webinar last week, where I did do this. It was a technically challenging webinar where an awful lot of things were happening at the same time. So I did this at extremely high speed, but it seemed to me quite helpful and important actually just to orient ourselves in time and place as to what has and hasn't changed in relation to the law. And then Steve's going to pick up in particular lots of things which have been going on with guidance, but I just want to be thinking about how the law has and hasn't changed. So apologies for being slightly naff on this. I really am taking this literally. This is the ABC. So this slide is as before. So as before, things that haven't changed. And these are core goal things that help us orient ourselves in terms of what we can and can't be doing. And if you're engaging with the statutory service, what they can and can't be doing. So number one thing that hasn't changed is the Human Rights Act. Indeed, in some ways, the Human Rights Act has become even more important because, as I'm going to come on to, in those local authorities where Care Act easements have come into force, the Human Rights Act and the duties imposed by the Human Rights Act have become even more important. But also the Human Rights Act is incredibly important in terms of thinking through both the positive obligations on the state to secure, for instance, people's right to life, and also the negative obligations not, for instance, unlawfully to deprive people of their liberty without going through proper checks and balances, or not unduly to restrict people's autonomy. And having gone from an incredibly hardcore series of restrictions on autonomy, one of the things and one of the reasons I think Sam wanted to have this webinar was they're now in a position where autonomy is being nuanced in more or being interfered with in more nuanced and more complicated ways. That's good in lots of ways because it's not so much blanket you can't, but it makes it much more complicated in some ways to navigate. So one of the things to be thinking about is how Article 8 and the principles of Article 8 of autonomy, the right to private and family life, provide a moral compass as well as a legal compass through some of the really difficult things and dilemmas that people are encountering. So that hasn't changed. The Equality Act hasn't changed. And for those people on this call, I really don't need to be reminding about the Equality Act, and in particular, the importance of making reasonable adjustments. So much, I actually think one of Steve's best tweets of many, many millions of tweets that he's put out was about last week, saying, most of my work in this area has been reminding government that people with disabilities exist. I mean, really, that shouldn't have to be done, but that has had to be done. And so many of the areas where work has had to be done at speed is to make reasonable adjustments for things where perfectly, as it were, sensible policies were put in place, which seem to entirely fail to recognize that if you've got somebody with a specific impairment, things have to be done to adjust, reasonable adjustments, to make sure that the impact on them is not overly severe. Mental Capacity Act hasn't changed. It really hasn't changed. I can't emphasize this enough. I can't emphasize how green it makes me feel as a lawyer when I have conversations with really hardworking, really good people who seem to have got the understanding the Mental Capacity Act has been ripped up. It really hasn't. It really, really hasn't. And if anything, the principles of capacity, and if someone lacks capacity, after all practicable steps have been taken to support them to take the decision, the principle of best interest decision making is just as, if not more important than it ever was. Mental Health Act has not changed. Some people seem to be of the view that the Mental Health Act amendments, which were included in the Coronavirus Act, have come into force to reduce some of the safeguards around it. They haven't. As far as I can see, there's no intention to bring them into force. But so Mental Health Act remains in force with full force and effect, except I should just flag, the Department of Health and Social Care has identified in England some cogent reasons for departure from the code. You can find those in legal guidance, which was issued by the National Health, NHS England and Improvement and the Department of Health and Social Care at the end of May. You can find all the resources I'm talking about here on my website. I'll show you that at the end. I mean, you can find them in all sorts of other places, but I've gathered them there together. There, they have identified there's some circumstances where it's difficult to comply with the soft obligations, the practical obligations imposed in the code, and there are cogent reasons for departing. One of the areas, for instance, which people have got quite exercised about, and I understand why, is, for instance, the ability to carry out assessments, Mental Health Act assessments over video. Department of Health and Social Care says they think it's legitimate to do so, although that's a departure from the code of practice. Tribunal procedure has changed, in particular moving to remote hearings and in some circumstances moving to one judge only, as opposed to the conventional panel. The tribunal is trying to get itself back on track, but as with all the courts, they are having difficulties. Last bullet point there, I can't emphasize enough, has not changed. Advocacy duties. IMCAs, IMHAs, Care Act advocates, Social Services and Wellbeing Wales Act advocates, their duties, and I know I can see some of you on the call, you are here, your duties and the duties to instruct you are just as important as they ever were. The practical challenges for carrying out advocacy duties may be more complex, but those duties haven't been alleviated anywhere by any of the changes. So that's as before. What's brand new? Well, what's brand new is the health protection coronavirus restriction regulations. And they are the ones which changed at the beginning of June in England. They've changed also in Wales and Northern Ireland and Scotland. I can't emphasize enough. If you're listening in Wales in particular, you need to be very careful to make sure you're looking at what the regulations say in Wales. They're not quite the same as the regulations in England. So these were the regulations which had in them what I called on my website to begin with, and then I got told off for doing this, the house arrest regulations. The ones which for a couple of months said you were not allowed to leave your house without reasonable excuse. And that provoked an awful lot of heartache and an awful lot of complexity in terms of what reasonable excuse meant. Now we've got easing of the lockdown into you're allowed. There is nothing else now about leaving one's home without reasonable excuse. That's gone. The focus now is on staying overnight without reasonable excuse and taking part in gatherings, either outside or inside. And this is an example, and Steve is going to touch on this as well, of how what had been a very, very clear, extremely draconian, but very clear message contained in law is now much more nuanced, which makes it more complex. It's better in lots of ways. I don't want to say it's negative in lots of ways, but it's positive in lots of ways, but it makes it more complex. It makes it more complex in terms of navigating. It also makes it much more complex in terms of visiting. For instance, visiting someone's home, visiting a supported living placement, visiting a care home. Steve is going to be talking about that in a minute. But that piece of legislation, that those regulations, which have been amended several times, most, as I say, most dramatically on the 1st of June, that was brand new legislation which just didn't exist before. By the way, if you're wanting to read more about this, I did an article about it on my website, which went live, as it were, on the 1st of June, trying to think about it from the perspective of people with impaired decision-making capacity. The other bit of brand new legislation is Schedule 21 to the Coronavirus Act. This is the bit which has given public health officers powers to require people to attend for testing, to make sure people are tested, and if they're suspected of or considered established to have coronavirus, require them to remain in certain places, including in isolation for specific periods of time. Those powers are not capacity specific. Those powers could be applied to anybody. I mean, Steve, me, Rachel, Sam, they could be applied to us. But one of the complexities is how those powers interact with, for instance, the Mental Capacity Act and DoLS. DHSC gave us emergency DoLS guidance. They've updated it and amended it to try and deal with that in a little bit more detail. I have to say the detail there is still not enormously great. The number one point I would make is at all times when it is legitimate to do so, reliance on and consideration of the position from the perspective of the Mental Capacity Act is significantly better than reliance on anything under the Coronavirus Act. There are a number of reasons for that. One is a practical reason. There are very, very few public health officers in the country. Two, public health officers actually have got very limited powers, for instance, to bring about the enforcement of an order. So in circumstances of isolation, there's very limited things that a public health officer can do. And people operating in care environments have got themselves understandably in fantastic tangles trying to work out to what extent is a public health officer going to be able to help me with. The other point I would make, it's a nerdy, techie legal point, but it's one that's really bothered me. And I'm fairly sure something is going to be done about it quite soon, which is going to make me at least happy, is nowhere in Schedule 21 does it say how you can appeal against an order made by a public health officer if you've got impaired decision-making capacity. So the order could be made against you saying, you must stay at this place in isolation. How do you challenge that? Well, you can challenge it before the magistrate's court. But what if you don't have capacity to participate in those proceedings? It's blindingly obvious, and I'm seriously hopeful that guidance is or something is going to come out which makes this even clearer quite soon. It's blindingly obvious that someone must be able to bring an appeal on your behalf. But that's one of the areas where the law hasn't sensibly caught up with the needs of those people who may not be able to make their own decisions. So we've done as before, we've done brand new. And then I just want to flag up a couple of things where there have been changes. Changes, the first, and these all came in as another part of the Coronavirus Act. First is in terms of changes to the duty to carry out continuing healthcare assessments, NHS continuing healthcare assessments, or in England. It's not saying there is no duty to provide NHS continuing healthcare, but it's alleviating the duty to carry out the assessment. The idea, the government said, is to try and make sure, for instance, where somebody is being discharged from hospital, you'll remember the mass move to discharge people from hospital. The idea the government said was that assessment for CHC funding should not delay discharge from hospital. I think it may, in fact, have more wide implications than that, but that's what the government was saying it was supposed to be there for. The Care Act easements, so in other words, this is not a word that appears in the Act, the Coronavirus Act, it's the word that appears in the government's guidance in England. That's the bit which says where they apply, public authorities are able essentially to turn the duties to assess and make a provision for needs under the Care Act into powers, unless it's necessary to meet the person's needs so as to comply with the European Convention on Human Rights. And you remember a minute ago I was saying the ECHR Human Rights Act, even more important than it was at some times, particularly important here. But I can't emphasize this enough at the moment. There are only 2 local authorities in England who are making use of these easements. It was 8 at one stage, it's gone back down to 2. And I think quite a few local authorities, in fairness to them, thought they were having to think about easements in circumstances where they were finding it difficult, for instance, to carry out Care Act assessments remotely. They thought they were having to deploy Care Act easements, the statutory easements, in order to meet that challenge. In fact, that wasn't what those easements are there for at all. They are only there for when a local authority genuinely cannot carry out its duties under the Care Act. And there's a strict process which has to be gone through. So as things recede in some areas, get more complex in others, one area where the tide is receding slightly is in relation to Care Act easements. The tide never went in, for anyone listening in Wales, I don't think this metaphor works, but the tide never overwhelmed the Social Services and Wellbeing Act in Wales. No local authority in Wales has sought to bring into force the easements. So that's a kind of slightly less whistle stop for the people who were listening last week in the NMCF webinar, but a still reasonably whistle stop tour of the legal ABC. So then I wanted to hand over to Steve, who's going to pick up on some specifics of things that we had flagged to us via Sam, and then we will deal with questions as we go along. So Steve, I shall now, next slide, please. I think I can read your mind.
Yes, next slide, please, Alex. Thank you. I'm also going to need to share my screen at certain points, so I'll duck out into my screen to show some guidance documents and then come back to you if that's okay to move the slides on. So the first of the specific issues that I wanted to cover was the very thorny question of the shielding group, of course, those who are deemed to be exceptionally vulnerable to the virus. And to emphasize that we have new guidance for that group as of the 5th of June, so very recently. One of the things that's striking about the pandemic is how time morphs, and sometimes things that seem to have happened about 10 minutes ago happened about 2 weeks ago and vice versa. This guidance, I'm reliably informed by the internet, came out on the 5th of June, and it is guidance, as is underlined on the slide, and that means it's not law. And that distinction between law and guidance is really important in terms of understanding people's rights and obligations as well, because if something is guidance, as the name suggests, you are being guided towards a particular position. You are not being required as a matter of law to do it. So what was done on the 5th of June, the government update list, very helpfully, all the guidance documents, you can see a list of what is changed on what dates. Some of them are quite long. And the update for the 5th of June is that it's been changed to reflect that those who are shielding can now leave their homes. Well, of course, as a matter of law, they already could. What it perhaps should say is that the government guidance is that they may leave their homes. And what's suggested in the guidance is that if you are going to leave your home, if you're in the shielding group, you should do so either with members of your own household, or if you live on your own, meet one member of another household and try to make sure it's the same person each time. And the obvious implication of all of this is that there is still a serious risk in terms of infection from the virus for this cohort. So there's been an easement, to coin the common phrase these days, of what's suggested to be the restriction for the shielding group, but still a very clear recognition that the situation isn't safe in broad terms, and people still need to take very significant precautions. I would strongly suggest that anyone who's in the shielding group reads this guidance very carefully and forms a view for themselves as to what is appropriate, because certainly anyone who spends anywhere near as much time as I do on Twitter will have seen very significant concerns about this guidance and very significant concerns about whether it's appropriate in the context of the progress of the pandemic. So those who have capacity can, of course, make their own decision as to whether or not to go out if they're in the shielding group. For those who lack capacity, that decision will be a best interest decision. And I'll come back at the end to some very broad principles that we'd suggest would inform those kinds of decisions. And as with every best interest decision, it will be a balancing exercise where the benefit of leaving home in terms of people's wider well-being needs to be balanced up against the risk to them and others of infection. So just because the guidance says that people can, in quotes, leave their home, doesn't mean they have to leave their home. It's a matter for individual case-specific decision. Next slide, please, Alex. Thank you. Right on time. This one I'm going to have to duck out to show people because I think it's really important. It's striking that the questions that have come in before the webinar and during the webinar so far have very much been dominated by this question around visiting restrictions. And in particular, visiting restrictions in non-NHS settings, i.e. care homes, supported living settings, people's own home, where care providers might be saying, no, we can't have visits. What's important and new for the theme of this webinar is the new NHS guidance that came out again on the 5th of June, busy day for guidance, which now permits visits to NHS settings subject to what's described as local discretion. And I will duck out from the slides for a moment. Hopefully this will work to show you the relevant guidance. It's here. So I hope people can see. Alex, can you nod if you can see the NHS guidance? Thank you, that's really helpful. We'll see, you see it's titled Visiting Healthcare Inpatient Settings During the COVID-19 Pandemic. So on its face, it's NHS guidance for health settings, replaces the 8th of April guidance, and it says in terms, the national suspension on visiting imposed under that guidance, just pause there again to consider whether guidance can impose anything, is now lifted. Visiting shall instead be subject to local discretion by trusts and other NHS bodies. So what the guidance is saying is it will be up to local NHS decision makers to decide whether it's appropriate in all the circumstances for people to be able to visit. And again, if there's any doubt, the word may is used. So the guidance is providing advice on how NHS organisations may choose to facilitate visiting across healthcare inpatient settings. So it's not obligatory in any sense. And then there's a series of what I suggest are quite helpful practical considerations to support visiting that are set out in the guidance, limiting the number of visitors at the bedside, informing visitors in advance about what to expect and giving practical advice. Visitors must wear masks or face coverings at all times. Now, I would commend to everyone on the webinar an outstanding piece of work that Dr. Oliver Lewis, our colleague at Doughty Street Chambers, has done today, published today, on the World Health Organization's guidance on mask wearing and health and care settings. He's gone through a painstaking process of analysing the English, Welsh, Northern Irish and Scottish guidance, which overlaps and contradicts in this area. But the essential point I took from that post was that the WHO guidance is that mask wearing is appropriate at all times. There are, of course, going to be issues with that, and we'll come on to that in a moment. But where there are no reasons not to, this guidance that visitors must wear masks or face coverings at all times seems to me to be consistent with the WHO guidance. Obviously, anyone who's showing symptoms shouldn't visit, and other people who are in attendance, this is very important, other people who are in attendance to support the needs of the patient, for example, a familiar carer, supported personal assistant, should not be counted as an additional visitor. So recognising in a very welcome way, I'd suggest, that some disabled people will need more than one person with them to facilitate their day-to-day needs. So I'd suggest this is a very welcome development. If we could go back to the slides, which I think I need to do by stopping sharing my screen, so that Alex can now start hopefully to share his screen again. Oh, look at that, seamless, Alex, well done. The big point here, I'd suggest, is the lack of any new guidance for care homes and supported living settings. Alex and I were knocking about what that meant before we came on, and I think our shared view, Alex, is that the principles in that guidance must surely translate to care settings, because there's no rational reason why it could be safe for people to visit a health setting but not a care setting. Well, put it another way, if there is a rational reason, it would need to be presented on the facts of that particular case. At a general level, It's hard to see why a care home per se is more vulnerable than a hospital, for example, or a mental health unit. So if visiting is permitted in health settings under the guidance, why isn't it in relation to care homes and other settings? Of course, we simply don't have guidance. We just don't know what the department's position is on that at the moment. So again, it will be a matter for local discretion, but that discretion has to be exercised in accordance with a number of legal principles, including, perhaps most importantly, Article 8 of the European Convention on Human Rights, people's right to respect for their private life, their connections with the wider world, and their family life. So I'd suggest that any blanket policies, which is what are being raised to us in the questions, blanket policies saying absolutely no visiting in any circumstances, are likely to be hard to defend. How would you challenge a blanket policy like that? Probably through an application for judicial review. It's very interesting looking at the BM and Surrey case, which is the only court of protection case, or certainly the leading court of protection case looking at these issues during the pandemic. What the court was asked to do in that case was not decide whether restrictions on visiting were in P's best interest. The choice for the court was between the care home with the restrictions that the care home wanted to operate and P going home to live with his daughter, if I remember right, because those were the two actual options on the table. The option of unfettered visiting or less fettered visiting just wasn't available, and so that wasn't the choice that the court could make. If someone had wanted to say in that situation, well, it's unlawful to stop me from visiting, it seems to me that the remedy there would have to be judicial review. You'd have to be saying to the provider or the commissioner, these restrictions are unlawful, whether because they breach Article 8 or for another reason. So it's probably the case, bearing in mind that neither Alex nor I are giving legal advice today, but it's probably the case, in my view, that those kinds of challenges would need to be brought via judicial review. What is definitely the case is that if you have a challenge like that, you need advice as quickly as possible on the facts of that case. Okay, moving on for reasons of time, but that is an important one. Where are we going next, please, Alex? Test and trace. Okay, so this raises very significant concerns, of course, as well. The new guidance on this issue came out on the 27th of May. And in very short terms, what people are being told now is that at the point they develop symptoms, anyone develops symptoms of coronavirus, we're to isolate, self-isolate, and to order our test. And if we're not one of the prioritized groups, we simply do it from the NHS website. Once we've done the test, and if it comes back positive, we're expected to do two things. Firstly, share that information with anyone who we've been in contact with so that they themselves can be tested, and then continue to self-isolate in order to protect people around us. Now, Alex and colleagues at 39 Essex have done a very helpful note on this exact issue, which I'm now going to, oh, sorry, Alex, could you stop sharing? Thank you. Take people to briefly. Because I think it's extremely helpful, not just on testing actually, but on all of these questions when they're applied to people who lack capacity. So this is a note that you'll find on the 39 Essex Chambers website, the rapid response guidance note on testing for COVID-19 and mental capacity. And it's actually quite old now in pandemic terms. It's positively Jurassic, it's over a month old, but I think it still stands up very much to scrutiny. And so the context, I think we understand that testing is a key part of the strategy. And so the expectation is that people are going to be tested. And in some situations, it's a requirement, for example, to go into a care home. Paragraph 4 of the notes suggests that most people will want to be tested and will have capacity to consent to that. But the problem arises if a person doesn't have capacity to consent, and in particular, if their behavior or otherwise suggests that they don't want to be tested. What do we do in those situations? So the note says, and I agree, that will be a standard best interest question if a person cannot consent to be tested, unless there's an attorney or deputy who can give the relevant consent on their behalf. I also firmly agree with colleagues in the note who say there can't be a blanket decision that testing is in the best interests of a particular group of people. It has to be an individual decision. But colleagues go on to say, I think this is very much Alex's work as well, and I agree, that it's likely for the following reasons that having a test for coronavirus would be in a person's best interest. And I'm not going to read out every paragraph of the note, but what I would stress is what's said here at D. I think this is quite important, first of all, that the best interest checklist provides for other factors that he would be likely to consider if he were able to do so, which might, depending on the person, include the effect the decision will have on those around them. And then the footnote here is to the report on mental capacity that led to the Act and Aintree and James, suggesting that best interest includes altruistic sentiments and concern for others. So there is room, we suggest, for consideration of not just the person's own individual selfish interests in the narrow sense, but the interests of people around them, including other residents, for example, of the setting where they live. So would the person see themselves as a responsible citizen, for example? But also, even if it's clear the person wouldn't want to be tested, the best interest test is not, as we know, a pure substituted judgment test. And so you can take into account other factors, including, as we say here, the potential that the person might cause a risk of harm to others in deciding whether to override their known wishes. And the footnote here is to Birmingham and SR, paragraph 41. So again, that's a very important point, because it's a question that comes up, and indeed I was asking, to what extent are wider considerations relevant to best interest determinations? And perhaps unsurprisingly, the answer is that they are relevant, and the reference here to Scripple for the idea of being a responsible citizen. So taking all that into account, the authors of the note and I suggest that it's likely that testing will be in the best interests of the person. Legitimate for the relevant professionals to take into account the public health risks in play in determining best interests, even in the face of a known desire not to test. And although the test may be uncomfortable and invasive, obviously we have to try to do it in a way that is least restrictive, that doesn't involve restraint. If it does need to involve restraint, we need to look at section 6 of the Act and whether those conditions are met, and that does focus on harm to the person, and some guidance given on there. Obviously, we need to think, and this is the caveat that's given, about cases where there's proper evidence that there would be serious distress or harm caused, and in that case, you'll be unsurprised to know that what you should do is take legal advice, because that's difficult and will need to be looked at on the facts of the particular case. Testing probably isn't serious medical treatment, etc. I won't go through this in any more detail just for reasons of time. I would commend the rest of the detail to anyone who is concerned about this issue. But I think the principles that we pick out, or picked out in the note, in particular of the ability and perhaps the requirement to consider wider interests in best interest decision making, is going to be relevant to a number of the questions that I'm concerned with in this section of the talk. I'll stop sharing again. Go back to the slides. Thanks, Alex. So face coverings is another issue that's caused huge concern amongst the community. This is an interesting one, because the policy was announced through the media, as these things generally are these days, on the 4th of June, with a statement that face coverings would be compulsory in certain situations, which we'll come on to, from the 15th of June. But since that date, I can't find any official confirmation of this, or I certainly haven't seen any draft regulations or anything of that sort. We expect that if that is going to be an actual legal requirement, that will be done through regulations, and therefore it will be a matter of law, but we wait to see. What we're told is that this will cover people using public transport, that's quite broadly defined, in England. Again, this webinar being very focused on England because of the devolved nature of the guidance and the secondary legislation in this area. And what was said in the media at the time is there would be exemptions for very young children, although very young isn't defined. Disabled people, again, not clear whether that's all disabled people or only disabled people who have a relevant impairment, and those with breathing difficulties. And there's the potential for people to be fined, apparently, for non-compliance with all this. Real concerns that arise here, particularly, I think, in terms of the potential for stigma and discrimination if someone isn't wearing a mask, and what are they going to need to prove that they have an impairment of a relevant type in order to avoid being chucked off the bus or fined. That's obviously very concerning. Also, in terms of best interest decision making, again, it's probably not necessarily in the individual's best interest, or it may not be in the individual's best interest to wear a mask. As I understand it, and I'm no scientist, the evidence base for masks protecting oneself is quite weak. What is much clearer, it seems, in the evidence is that wearing a mask serves the communal good, that it tends to make you less infectious to others. And so we need, again, this case law that shows that wider considerations are relevant to best interest decision making in order to support a best interest decision that a person who lacks capacity to decide whether to wear a mask should wear a mask if they're going on public transport. Again, please, Alex. And then another question that came in beforehand was, what about disabled people returning to work? Well, again, this is one where perhaps legally it's quite straightforward, although in practice I'm sure it's much more complicated, because legally work was always a permitted reason to leave home. And so, although Regulation 6 has now been completely changed, as Alex mentioned, instead of being a ban on leaving the house, it's now simply a ban on staying somewhere else overnight. Even when it was a ban on leaving a house, it was subject to reasonable excuses. And one of the specified reasonable excuses was if you had to leave home to go to work. So people were always allowed to work. I can't see any legal impediment to disabled people working either now or at any point in the pandemic. Of course, if you're in the shielding group and your work involves contact with others, it seems to me that you shouldn't be expected to work, because the guidance has only been changed to allow this very modest excursion from home. It's certainly be very difficult to work in a factory or a shop environment, for example, if you're only supposed to meet up with one person from outside your own household. And of course, employers have duties to make reasonable adjustments too. Now, employment law is a whole other can of worms, and the application of the Equality Act to employment law is worthy of a series of webinars of its own. I'll just mention that the reasonable adjustments duty applies to employers, and people who are concerned about employers operating fixed policies and not taking account of their disability-related needs should be getting specialist advice. Moving on again. Just trying to pull the threads together of these specific examples. I think it's always important to stress in any capacity-related talk that people who have capacity to make the relevant decision at the relevant time can do whatever they want. They can decide whether to comply with any guidance or indeed with the law. And they can take the consequences if they don't, whether that be a fine or any other kind of sanction. So people who have capacity to make decisions, that get to make their own decisions and as the slide says, and to take the consequences. Those who are assessed not to have capacity to make a particular decision at the relevant time, we are simply again in the realms of best interest decision making. And to echo one of Alex's themes, nothing magically changed in the way that the Mental Capacity Act operates when we started to get cases of coronavirus diagnosed. It would be a very odd situation if a public health emergency like this suddenly meant that we didn't have a Mental Capacity Act, or we didn't follow a best interest approach to decision making. I'd suggest actually it's quite the reverse. It just cements the need for very careful and considered best interest decision making, as should already be happening. So those who are seeking to uphold proper decision making standards, and advocates and others, need to gird their loins, I think, and go back into battle, because the need is even more pressing now, rather than less pressing, that things should be done properly. So the usual principles of best interest decision making apply, which, as I hope I've shown you through Alex and others' excellent work, include consideration of the wider interests of the community. And it's always important to distinguish between law and guidance, because there are clearly different imperatives to ensure that a person who lacks capacity complies with the law than there are to seek to ensure that they do what's said in guidance. Those are qualitatively different things. Obviously, the fact there is authoritative guidance in an area is a relevant consideration for best interest decision making, but perhaps not as weighty as the fact that if you don't do something, you'll be breaking the law. So it's very important to identify the source of any apparent obligation that you're trying to make sure a person who's said to lack capacity complies with. So I think that takes me to the end of the specific issues and these general points on the principles. I just put the link to the guidance note on the slides, which I think are going to be circulated. You can find it using a trusty Google search as well. And now, Alex, I think we're about to do our double act on the questions. Is that right?
Yes, although can I just spend 2 seconds just talking about just some further resources? So the first is that there is our Chambers website where you can find all sorts of resources, capacity related resources. The case, for instance, the BP in Surrey case you talked about, you can find the case summary there. And that's where you can also find that testing guidance. We also did one on social distancing, which is in the process of being updated. And also thinking about more generally about the fundamentals of capacity best interests, and various other resources there. The one, can I just single out to blow my own trumpet for 2 seconds? The fourth one down, mental capacity law and policy.org.uk. That's my website. And on that, I've got a selection or a section of MCA and COVID-19 resources. Because I don't know about you, but I am still slightly drowning in the amount of guidance which is out there. The flood has slightly slowed, but not completely, and I'm really worried that people don't necessarily aren't able to find all the bits in one place. So that's why I try and pull it together in one place. It's been most recently updated this morning because I wanted to make sure it was pretty much up to date before we did this webinar this afternoon. And then you can find our Twitter handles there at Steve Broach, at Capacity Law. You can also then find our email addresses easily by Dr. Google. Just to emphasize, we can't give direct legal advice now, nor can we do it as it were off our own bat if people just email us. But we're always, unless we're instructed to do so by a solicitor, but we're always happy, well certainly I am, and I think you are too, Steve, you'll speak for yourself, always happy to point people towards guidance, point people towards things in a general way. So that's just what I wanted to say. But then in terms of questions, Steve, I think quite a lot of people have said, just as you were talking, going through what they were saying, going through the Q&A thing, I think people would find it really helpful. Could you just do a very, very short recap of the visiting restrictions? Because I think it's obviously new to quite a lot of people. I think that would help them just to see it again. Or have you said?
Yeah, happy to go back to it, and I think I should share the screen and show it again. That's probably the easiest.
Shall I? The one you wanted to show? Yeah. Okay.
Yeah. Do you want to come out again? And thanks, Max. That's great. Brilliant. So, just going to get my zoom out of the way. There it is. I mean, the joy of the visiting guidance is it's really, really short. So compared to some of the other things you might have to read, I think there's about a page and a half of substantive guidance here before we get to the appendix, which is all about virtual visits anyway. So just to stress again, this is NHS guidance, so it's for healthcare settings expressly. We think that the principles of this must apply by analogy to care settings, but there's no authority for that. That's simply our view as a matter of rational decision making, and also to avoid discrimination as well under Article 14 of the Convention, I'd suggest. So expressly for the NHS, we know that because of the big logo in the corner. By implication, we'd suggest for care settings. Superseding and replacing the old guidance, so you can throw that away or put that in your archive file, virtual or otherwise. Clearly lifting the national suspension on visiting and saying it's up to individual trusts and NHS bodies to decide locally whether or not to permit visiting. And the implication of that, I think, must be and on what terms. Because if there's a local discretion, then that could be an absolute ban, complete free-for-all, or anything in between, obviously subject to public law considerations like rationality.
Steve, can I just jump in there? It is absolute, and you know this, and I think just to reinforce to people, blanket bans on visiting are undoubtedly in breach of the European Convention on Human Rights. I mean, there's quite extensive case law from the prison situation, including high security prison. If you can't really think of anywhere which is more likely to be able to say you're not allowed to have anyone. And even in that context, the European Court of Human Rights has said you simply can't have a total blanket ban. You've always got to have something which reflects the individual circumstances. So to the extent that there have been blanket bans out there, they are undoubtedly, I don't normally like giving totally blanket statements, but in my view, they're undoubtedly unlawful. And this makes it even clearer that to the extent that anyone seeks to maintain what looks like a blanket ban, they are on legal ice, which is so thin as to be, you know, that bit in Roadrunner, you know, where it goes off the edge of the cliff and there is nothing.
The feet are still going, yeah.
Yeah, there is just nothing. But sorry, just, I know blanket
No, that's
bounds is
helpful,
something
Alex,
which really exercises people.
I also completely agree. Absolutely right. So what I then took people to was, apart from flagging up, it applies across a range of settings, what are described as practical considerations. And of course, this, again, it's just mere guidance. So it's not in any way a legal rule. It's suggested that the number of visitors should be limited to one close family contact. Suggested, and this is obviously just good common sense, that people are told in advance what to expect. And the one that I particularly flagged up, apart from the wearing masks or face coverings at all times, was the very welcome recognition that some people will need support from more than one individual. So the visitor would be on top of a personal assistant or someone who generally is with that person. So there's no discrimination against those who have additional support needs. But all of this in the context, as it says at the top of the guidance, that the health and safety and well-being of patients, etc., remains the top priority. So the public health considerations are still very real, very significant, but there's a much more nuanced approach now than was recommended before. So that, I think, was probably what I need to say about the guidance, unless there were any other questions. I see lots of questions came in on face masks as well. I'm very happy to say a bit more about that, if that's helpful. Was there anything you wanted to come back on, Alex, from your part at all?
Not on, well, so various people have been asking me questions down the side about, for instance, remote assessments, and I've been dealing with them. And also there've been a couple of questions about whether testing is serious medical treatment, or sorry, whether testing is something to which the duty to instruct an IMCA arises. And I was just in the middle of frantically typing something to someone to say, no, because of the very, very tight way that Section 37 of the Mental Capacity Act is drafted and the accompanying regulations, partly because it's only about serious medical treatment. And in most cases, carrying out a coronavirus test is not serious medical treatment. It might be in some cases, but not as a general rule. And also in very many cases at the moment, testing simply isn't going to be carried out by an NHS body. So it is undoubtedly, in my view, a gap in the sense of it would be very good if there was a duty to instruct an IMCA in an awful lot more situations. But the way the law is drafted, I simply don't see, and the colleagues of mine who wrote the guide with me simply don't think that that is in fact how the law works. The only other thing, I had one comment to make about face masks, but as you were leading on it, do you want to go first and then I'll pick up afterwards?
I'll try and run essentially all of the face mask questions together and see if I can deal with them. So one very interesting question is, if a best interest decision was made for someone not to wear a face mask, who, if anyone, would take the potential consequence? Well, I think as a matter of law, the person. This is the sort of thing that needs to be worked through, as Alex is saying. How do you appeal decisions to the magistrates court if you lack capacity to bring an appeal? There will have to be, and I'm completely speculating, we have no idea what the scheme will say, but there would have to be provision in the regulations for a situation where a person fails to comply with the requirement, but they lack capacity to do so. We'll see if there is. I have my doubts, but until we know what, if anything, the scheme actually says about that, it's mere speculation, I'm afraid. There was then a question about exemptions to face masks. What evidence would you suggest people who appropriate for them, or perhaps that a best interest decision has been taken? Very difficult, I think, because you need to avoid stigmatizing people. The sunflower lanyard that's used by a number of supermarkets to recognize additional needs has been suggested, I've seen on social media, as a kind of model for this. But if there's going to be a national scheme, there probably needs to be a national recognition as to how a person can legitimately show that they are exempt from the requirement to wear a mask. Difficulties like this might explain, you could suggest, why we haven't yet had any publication of how the actual scheme is going to work, because I think the answer to that question is very far from straightforward. So one question again was, is there any consideration about the people who lack capacity and can't tolerate wearing a mask? Well, yes, we know there's been consideration of that, because in the announcement, it was said that there would be an exception for disabled people. But again, we don't know what the parameters of that exception will be. And then an excellent question, and I'm not saying names because I think for data protection reasons, and because this is being recorded, we're not identifying our questioners. But thank you for the question about the impact on deaf people. I think that's very significant. And also on other disabled people who lip read as well, because others wearing a mask creates a real problem for quite significant cohorts of disabled people. And there's been some suggestion that all masks should be clear, so people's lips can still be seen. And again, that seems to me to be eminently sensible. Whether it's a reasonable adjustment, I think would depend on questions of practicalities like cost. But it would certainly be desirable, at the very least, if all masks, or as many masks as possible, were clear, so that deaf people could continue, and others could continue to lip read and see and read facial expressions. Are there any other mask questions, Alex, that I could pick up? I think that's it.
There was the one about preventing travel.
Oh, yes.
I mean, air travel companies, Euro companies, could you prevent travel if you were traveling with someone who's unable to tolerate the mask?
I think in principle they could, because it said that the mask will be a condition of carriage. And so a public transport provider would legitimately be able to say you are not complying with our conditions of carriage because you're not wearing a mask, unless you could demonstrate that you came within whatever the exemptions are going to be. But this goes to a really unsatisfactory aspect of policy making and law making throughout the pandemic, doesn't it? That headlines get announced like this without the detail having been thought through. And that just causes huge concern and huge uncertainty for groups who are affected by them. And hopefully we get told what the answer is, but it may be the night before the regulations come into force, as it so often has been throughout the pandemic, and then certain people do sterling service on Twitter and elsewhere explaining what it all means. But that's not the way that law is supposed to be made and communicated, and there should be appropriate notice of these things so that we can give more definitive answers when we're asked these very sensible questions.
Yeah, and the point I was wanting to make, Steve, was all we've got in relation to face masks at the moment is that announcement that you've very helpfully taken us to. And until we actually know what the regulations say, we won't know what bits are in this guidance zone and what bits are in the you mustn't zone or you must zone. Given they're talking about fines can only, it must be somewhere in regulations, but it's going to be, the devil is really going to be in the detail for particularly the groups of people who questions have been asked in relation to here. Because I think this is the area where, I mean, obviously, government, taking a step back, is trying to find a way in which to move from a position that the only thing we can do is absolutely nothing and stay at home, to how can we effectively restart society in some way. But one of the kind of running themes of this, and one of the things that we've been really why we've done this, is it makes it an awful lot more complicated. And one of the real complexities here is going to be in the context of individuals who either can't understand they're meant to wear a mask, or I think the ones who are really troubling me are the people who can't understand, are extremely distressed by requiring to wear a mask. And then how it is, and government presumably is going to take some rather macro level trade-off between the extent to which they suffer versus the extent to which everybody else is put at risk. And it's going to be really important that people look very, very carefully at what the actual regulations say, and to the extent that guidance suggests anything else or leaves room for transport providers to get the wrong end of the stick, that people are very careful to leap very, very quickly on them to make sure that they don't get the wrong end of the stick.
Absolutely agree, Alex. And it's also, the context is everything in all these things, of course. And one of the important points of context is that it's already extremely difficult for many disabled people to use public transport. And the Equality and Human Rights Commission is specifically looking at transport inequalities at the moment for that very reason. And there's a lot of case law on issues around access to public transport, most notably Doug Paulley's case that went to the Supreme Court. So we've already, a lot of these groups who will be disadvantaged by the requirement to wear a mask are already facing significant barriers to access transport. And there's a real risk in this. This is a neat example of a general risk, which is that the pandemic just perpetuates and worsens inequalities that are already there in society. So I really do hope that government's thinking about this very carefully, and that what we get is careful and considered legislation and guidance that's been worked up with disabled people's organisations. And if it isn't, then I'm afraid it's probably likely to be yet another example of something that gets judicially reviewed as a result of the pandemic, which has been far depressingly frequent. Because, as Alex said, we have to put our hands up and say, what about disabled people? Could I just take this very interesting question about disabled people with severe learning disability who don't understand the 2-meter rule? And so if parents were to visit them in the garden, the person will immediately try and go and hug them. Well, one classic lawyer thing to do, I'm going to challenge the premise, because it's not a rule. The 2-meter quotes rule is guidance. It's what's recommended in terms of appropriate, I think the term physical distancing is better than social distancing. And in fact, there's been suggestions that the World Health Organization is saying 1 meter is actually the critical distance. But the English government guidance has consistently been 2 meters. But that is not, as far as I understand it, in regulations, nor has it ever been. So that's a slightly unhelpful answer, because clearly, in practical terms, people will need to keep 2 meters away in order to maintain and manage the risk of infection. And so in that context, it becomes a non-legal answer, which is, well, you'll just have to find a practical way of doing it, perhaps involving physical barriers or other ways of visiting that doesn't allow for that closeness. Or perhaps take a best interest decision that visiting isn't appropriate because the person will be so distressed by a visit that doesn't result in physical contact, because that's what they're used to. But those become much more fact-specific and fact-sensitive issues than they do become legal issues, so long as the relevant capacity and best interest principles are applied as they always must be.
Yes. I'm just trying, it's not that we're certainly not ignoring questions. We're just trying to find ones which we're not allowed to answer, ones which get too narrowly specific about individual facts. So I'm just trying to pull out those ones which we can take into a more general line. There was one aspect. Yes, I'm going to take a question which came 316. So those of you who are reading along can find out. Someone lacking capacity who's admitted to hospital for a care home for non-COVID related illness, then discharged, able to mobilize independently, unwilling to isolate for the recommended 14 days within a care home. How can the MCA be applied in this scenario at all? What restrictions can legally be applied to this individual and or others within a care home setting to minimize risk of infection to all living within the home? Would the home be able to accept the individual in this case? I wanted to take that question because actually that's not something we've really talked about at all today. It's featured quite heavily, and I think it was in our previous webinar, it's certainly featured quite heavily in quite a range of webinars at the moment about isolation and about where does the MCA stop. Where does, for instance, public health legislation start? The short answer is that the MCA stops and public health legislation starts at a point where either the person has got capacity to make the decision, for instance, to self-isolate and just doesn't want to, or the only reason that they are being required to isolate is risk of harm to others, not risk of harm to self. At that point, it becomes extremely difficult to say the Mental Capacity Act applies. That's the tenor of the Department of Health and Social Care's guidance, the emergency guidance, which they then updated very slightly and then gave some relatively useful additional stuff, partly by way of FAQs. One point I really just want to emphasize very, very strongly in relation to this, because I keep getting asked this, well, what about DoLS in this position? Deprivation of liberty safeguards, not the small mannequins. What about DoLS in this situation? Sorry, the only reason I'm smiling is that LPS, it's just reminding me, Liberty Protection Safeguards, which are going to replace DoLS in due course, also stands for the littlest pet shop. So we're continuing to move from small dolls to small toy shops. But back to this question we're just thinking about here. The first thing I always want to think about in this context is, why on earth are you only now thinking about dolls in the context of somebody who might be being isolated? If this person lacks capacity and is confined in some way in this care home and would be, but for COVID-19, what on earth is the care home doing not making the application to the supervisory body for a DoLS authorization? And the number of situations I've had where people have gone, right, I didn't think about that, it's actually really reminding us that notwithstanding the judgment in Cheshire West, which said, if you are confined and you can't consent, it is completely irrelevant that you appear to be compliant. Notwithstanding that judgment, people, I think in some circumstances, still are going, I don't want to, or I don't need to apply for DoLS until at such point as either the person's objecting or, ooh, hello, now I've got COVID-19 isolation, this feels different. So the first point I've been making is that DoLS should have been, probably in many cases, have been applied for already. I am extremely well aware, partly because I was at the Law Commission working on the liberty protection safeguards, I am extremely well aware that care homes who apply to local authorities for DoLS authorizations may not be able to get an immediate response, and they're very likely in many cases not to be able to get authorization within the period of the urgent authorization. I'm very well aware of that. DHSC is very well aware of it. But unless the care home, I'm really focusing on care homes here, but the logic would also go for hospitals. Unless the care home grants itself urgent authorization and applies for DoLS, they have absolutely no legal cover at all because they haven't done that which they're required to do. So I just wanted to use that question there to really emphasize, if DoLS isn't in place, it should already be in place. If a DoLS is in place or is applied for, then you need to think carefully about whether the additional restrictions required to give rise to isolation or to secure isolation amount to an additional deprivation of that person's liberty. At that point, you then have to be thinking very carefully about, how do I make sure that additional deprivation of liberty is authorized? But the DHSC guidance, which I've also done a walkthrough of that guidance and the later iteration on my website. You can see, a bit like Steve doing the walkthrough there of the visiting guidance, I did the same thing, go through and try and amplify some points. I've done that if people need more guidance on that area. So that's
that's really helpful, Alex. Unsurprisingly, I agree with every word of that analysis.
Phew.
Can I pick up two questions that came in together by coincidence at 324 and 325 for those following along? The first question is highlighting the challenges in terms of accessing testing, people in supported living and other settings, unless there's a specific outbreak. This is, in my view, blatantly discriminatory. I am really struggling to understand how it can be justified for testing to be restricted to those in care homes and not to be available for people in supported living settings, when in fact some supported living settings are in essence deregistered care homes. So what's the justification? There's clearly differential treatment here. What's the justification? Very hard for me to see what that would be. And so watch this space. You know, there is likely, I would suggest, to be a legal challenge to that. And anyone who's concerned about that issue is welcome to get in touch. But my understanding is it's correct that although as of very recently, younger disabled adults in care homes can access testing, and they couldn't do that for some time, even more obviously discriminatory. The supported living lacuna, if you like, is still very much present. The question at 325 is very interesting, and again, it's quite fact specific, so I'll take it generally, which is situations where a person wants to go home to spend time at the family home, which is probably permitted under the new Regulation 6 as one of the exceptions to the rule against overnight stays, but where either the manager of a care home or the provider of care in a supported living setting says, well, you can't do that because you can't come back because you'll then potentially infect the other residents. And I think, again, all I can say about that is to echo Alex's point, that blanket bans and policies are going to be extremely difficult to justify. To say no one can ever go and spend a single night at home, notwithstanding what the home environment may look like or how many protections may be made at home, etc., is going to be hard to stand up in court if it's tested. And again, would probably need to be tested by way of judicial review. So if anyone's concerned as to where they can get advice about that, if people search the term rights in reality and then solicitors, so rights in reality solicitors, that takes you to my blog, and there's a list there of some firms who will be able to offer advice, including those who've got the relevant legal aid contract for those who are eligible for legal aid. So a slightly unhelpful answer, I'm afraid, which is it will be a question that is decided on the facts of the particular case. But if there is a blanket ban, then much like Alex said earlier, the Roadrunner legs will be whirling and may not have much cliff underneath them.
Can I just give I absolutely agree with that. I think it is just important to remind people there is a difference between a blanket ban, which is a policy which just applies across the board without consideration, and a policy which may appear extremely harsh, that has been carefully thought through.
Yeah, I agree.
And I think there are quite a lot of scenarios where I have seen, and I don't know whether any of the people who have emailed in questions now or putting questions in now fall into this, but I have seen, and I suspect you have seen too, quite a lot of situations where people have perceived that there's a blanket ban. If you actually dig into it, it's a situation where there are very, very draconian restrictions, but actually the relevant provider, the relevant whatever, has gone through and said, this is why we really have to do this.
In this case.
In this case. And at that point, it doesn't mean that you shouldn't be careful to probe, if you're a family member, say, or someone supporting the person, why is it the case? But it's not quite the same. It is definitely, it's got a different flavor to it, to this has just been imposed across the piece without, as it were, thought for the individual circumstance. I do think it's just important that people hearing the message about blanket bans understand the sort of the thing which can feel identical, but in fact, in legal terms, is quite different.
Yeah, and the legal distinction, I think, Alex, is about the level of consideration, isn't it? Because a blanket ban is, there was a brilliant example that came across an old case involving Greenpeace trying to get permission to play amplified music at a protest. And there's some disclosure came out where the Secretary of State said, well, we have got a discretion to do this, but because it's quite complicated, our answer is always no. That's a blanket ban. But if the answer instead was, we don't think there should be amplified music, but we for these 7 reasons, but in every case we take account of the circumstances, that's not a blanket ban. That's a very strong presumption against amplified music, and therefore much harder to challenge. So it is distinct. It's something that lawyers immediately see, but that may not be obvious to people who aren't spending their time poring over the detail of policies and regulations. But it's a very important nuance. I completely agree.
There's a sort of group of questions. Can I just sort of cluster them, which are sort of to some, if I can take the theme, is what about the responsibilities on visitors? So in other words, you know, if visitors won't agree, or how can we deal with a situation where, for instance, parent, you know, the person doesn't have capacity, they want to see their parents. Parents are happy to visit and are happy to shield, or happy to undertake the various things required. I think thank you for that cluster of questions. I mean, they're different people at different times, but it's been a sort of sub-running theme. I think this is a really important aspect. One of the things in that guidance that you've flagged up there, the NHS guidance, visiting guidance, which we have said, and just to reiterate for people, we're saying until and unless there's specific care home guidance / supported living guidance, the sensible thing to do is work on the theory. That's the most up-to-date, most nuanced way that central government or a central body has said, how do you balance the risks here? Risk to life, risk to health, right to autonomy. How do we balance these various things? So even though it technically only applies in NHS settings, we're saying this is a set of principles which apply across the piece until we get something specific for care homes and hospitals. One of the things when you go down there is it makes it clear that the hospital or the trust, and for instance, the care home or whatever, can set out a series of things that they expect family members or visitors, because it's not just family members. It could, for instance, be a priest. You know, it could be someone there to come and provide religious support to someone, which could be hugely important. A series of things that they're expected to comply by. And if they aren't willing to comply, that is obviously going to have a major impact on whether it is the right thing in the circumstances of that individual patient, that individual resident's best interest, say, for the visit to take place. The other thing I would say is one has to then also think in the context of somebody who doesn't have capacity to make decisions, and for instance, doesn't understand the concept of shielding, doesn't understand the concept, the wisdom of the 2-meter rule, not that it's a law, but it's a good idea. You have to take that person as you find them. And everybody have to make their decisions around that. So you can't proceed on the kind of, well, if this person could only understand that they should do X, Y, and Z, this is how we proceed. You have to proceed on the basis, because of this person's cognitive impairments, with all the support in the world, and I know many, many people are really good at providing support to enable people to understand, with, for instance, the use of the brilliant books without words resources for people with learning disabilities, visual books, with all that support, they can't understand what it is and it is that they should or shouldn't do. For instance, if their mother comes to visit them or their father comes to visit, that's Donald Rumsfeld, that's a known known. It's not a known unknown, it's not an unknown known. That's a known known around which all decision making has to go as to whether it's, for instance, too risky to enable the visit. And that's where the tailored thing comes in again. It wouldn't just be blanket, it would have to be, well, that may mean that, for instance, we've got to make sure that the visitors are given a more hardcore set of PPE than it would be if the person was able to understand, actually, we need to see each other in the garden. I can't run up and give you a hug. But again, it's thinking, taking the person as they are, supporting them the best you can, taking them as they are, and then making sensible decisions around that. And that guidance there, when it talks about local discretion, really important, local discretion, but that definitely then also carries with it, discretion needs to be exercised sensibly and with sensible risk assessment. Discretion should, in an ideal world, and let's imagine for 1 second we're in an ideal legal world, always equate to sensible risk analysis, not being overly risk averse, especially in the cohort of people we're talking about.
Can I pick up something that's just triggered from what you said, Alex, about reasonable adjustments, the reasonable adjustments duty that's been troubling me recently, because I think people sometimes play a little fast and loose with that term. The problem with equality law is it's really quite technical. And that's particularly true under the Equality Act, the domestic legislation, perhaps slightly less true under the Convention. And the reasonable adjustments duty in the Equality Act, there are a number of different things that have to be adjusted, but the main thing that people focus on is the duty to adjust PCPs, provision, criteria, and practices, policies in it. And so you have to identify what's the PCP, what's the thing that's generally done that needs to be adjusted to avoid the disabled person experiencing a substantial disadvantage. And what triggered that thought, Alex, was you talking about providing more hardcore PPE, because that seems to me to be a brilliant example of a genuine reasonable adjustment, because the PCP in that situation, the provision, criteria, and practice, is we generally provide masks and gloves, for example, for visitors. That's the general rule, that's the general approach to ensuring visitor safety. But the adjustment that would be needed to avoid a substantial disadvantage to a severely disabled person who didn't understand physical distancing would be to provide more extensive PPE. That way, the reasonable adjustments argument works, but it's not a freestanding obligation to change everything. You've got to find the provision, criterion, or practice, the general rule that you're saying needs to be adjusted to make your reasonable adjustments argument work as a matter of law. That was a little homily on something that's been troubling me quite a lot recently. Can I go on to another specific question that I spotted when you were talking, Alex, which is the one from 315 for those who are following along, from an anonymous attendee. And thank you again for it. Really interesting question. So the scenario that's posited is that there are 3 people with learning disabilities who share a home. Only one of them is in the shielding group, in the exceptionally vulnerable group. And the suggestion is that you couldn't make a best interest decision for all 3 to shield, because it's only in the best interest of one. And I would question that because of what I said earlier on when I was talking about testing and shielding, about the need to have regard to the wider considerations in best interest decision making. And it may be, and the huge amount of stress in that sentence is on the word may, in the best interest of all 3 to shield in order to avoid the risk of cross-infecting each other. And also the 2 who aren't exceptionally vulnerable would be expected to want to look after the one who is, on an altruistic basis and on the basis that they are reasonable, civilized members of society. So I would question that assumption and suggest that people need to be thinking more holistically about best interest assessments in that scenario. There may well be countervailing factors that say it's not in one or more of those people's best interests. And of course, it has to be an individual decision. You couldn't do a blanket best interest assessment for all 3, but you could look at each case individually in the context that they find themselves in, assuming, of course, that it's in their best interest to remain in that setting. But that opens up a whole other set of questions that would need to be considered. Alex, can I check you agree with that? Because I think that's quite a thorny problem that we've been set there.
It is. It's an extremely thorny problem. It's also linked to the one at 340. How do we protect the well-being of other clients within a care home who aren't able or choose not to go out from another client who accesses the community and is unlikely to socially distance? I mean, it's linked that might be a situation where the person's got capacity to make decisions to go out and just is not interested in socially distancing. But we're in a zone where we are, in both zones, we're in a zone where we're trying to balance individual rights and a wider group of people. It's not the entirety of wider society. It's in the supported living placement with the three individuals. It's those interests across the board. And I do think I think it is, this would be a situation where, I mean, I agree with you that I didn't necessarily totally agree with the premise of that question, that first one, which is we simply can't make a decision that it's not in the person's best, the best interest can't encapsulate the interests of others there. We can't, as it were, have a best interest decision to shield across the board. But it is definitely a situation where, because I think, for instance, the Skripal case and the Code of Practice, the Mental Capacity Act, saying you are allowed to take into account factors that the person would have taken into account, including the idea, for instance, of this being this responsible citizen. And if there's any suggestion that from what we know of the person, their belief structure, and how they are generally, that they wouldn't want to put their friends at risk, say, that is definitely a factor which can be put into the best interest mix. But I think what I would want to be doing is be having a careful analysis of best interests, which obviously is individualized for each of the three people. And recognizing in relation to the other two, if they both lack capacity to make decisions, the relevant decisions, that what is happening with them is being impacted by the other person. But this is a really good example that, to some extent, the Mental Capacity Act is built on this complete lie that we're all individuals. We're just not. We all exist in groups together, and that supported living placement is a particularly good example of a group which may have been, as it were, to some extent artificially created, but now exists.
Yeah, that's a vital point, Alex, isn't it? It's the John Donne, no man is an island point. And it would be bizarre. Now, having asked the question of you earlier, I now think that it was a really stupid question to ask, because it would be completely perverse if the scheme of the Act didn't permit factors that are not directly relevant to the individual to be taken into account, because that it just doesn't reflect how people live. And actually what the pandemic has done is throw that into even sharper relief, because suddenly for a period of time everyone was expected to live in this very atomized way that people found exceptionally difficult. And then, as Alex says, the attempt is made to relax and to bring life back to something a little bit more like normal, and we find it's really, really difficult to get these balances right when there's still a public health emergency going on. But it's reassuring, looking at the note that's been done on testing, about the fact there's quite significant legal consideration, judicial consideration of some of these questions, and a general theme emerging of the need to take into account wider interests as part of a best interest assessment. I had another one that I've now lost. Have you got one in your hand, Alex?
No, well, I
found mine. Yes. Shall I do mine?
Yeah, go for it.
So it's a brilliant question that's asked towards the end of our thread about what happens where a care staff member is contacted by Test and Trace and told to isolate for 14 days and confirm all the other staff they work with would need to isolate. Does that mean that the home's going to essentially have to shut down because half of the staff are isolating? Well, again, Test and Trace is guidance at the moment. So there has to be the possibility of doing things differently in a scenario where the detriment that's caused by people self-isolating is greater than the benefit. But that has to be very, very carefully considered, with a presumption in favour of doing what the guidance says, which is isolating it at the point of experiencing symptoms and everyone else doing it too. But if the consequence of doing that were that people were going to be left to starve, then obviously that would be disproportionate and not the right approach. In real life, there'll be a more nuanced set of consequences, and that will have to be taken into account. So the guidance on Test and Trace I didn't specifically go to just for reasons of time. It is reasonably lengthy, and it does set out some exceptions or some caveats, and it's going to be very important to consider that carefully before answering a question like that. But what I think is really important as a general point is not to not to take the guidance in any area to absurd lengths. And that is something that there's a real risk of people doing when guidance is applied mechanistically, because it isn't law, and because it's not law, it generally goes a lot wider than the law. And so it shouldn't be followed as if it is law, because otherwise you're not doing it right. You're not taking guidance. You're treating it as if it's binding rules.
And the other point that I agree with you entirely, Stephen, and the other point, as someone else has pointed out, is one of the other things that's going on guidance-wise is that support staff, people in care homes, are now supposed to be wearing PPE. So
Right.
To some extent, there should be very, very minimal, if any, impact on or risk of transmission, even
Yes.
if the person is at one remove from the individual who has been told, you've got COVID, therefore we're now activating the test and trace.
Quite. And taking that to absolutely absurd extremes, if test and trace was operated in that way, all of the COVID wards would instantly shut down, because every single member of staff on that ward would have been in contact with someone who has COVID. So it just can't be like that, can it? And as Alex points out, if people are in effective PPE, then that might be an exception. Although I think there's real concern, isn't there, about how effective PPE has been outside of clinical settings, and whether we just don't really know, I think, because it's not reported what's going on in care homes in terms of PPE. And supported living settings probably even more concern. So that's right, but with a big but about whether the PPE that's being used is entirely in accordance with the recognised guidelines, and it's going to be effective.
Yeah, which I think sort of reinforces one of the things which makes lawyers' lives interesting, and for everybody else a nightmare, because whenever a lawyer says interesting, everyone else should panic, is that what we're doing, what's going on is we've got bits of guidance coming out from different places saying, not always absolutely the same thing, but bits of guidance. We've then got regulations dealing with different things. And then we've got other bits of law which are equally applicable, but aren't necessarily directly, obviously related to the regulations. So bits of law, for instance, about employment law and the duties on employers to provide, for safe environments for their staff. So there are all sorts of things going on there where, unless you've tracked that through, that particular maze, then thinking it through in terms of, well, how do the various decisions which people might now have to intersect with everything? And obviously one of the difficulties is that so many organizations, big organizations, the NHS being the biggest, but also huge other organizations, have had to try and turn themselves around in the last 3 months in all sorts of different ways, making sure that everybody within those organizations and everybody with whom they're interacting actually is clear as to where they stand on all the different things is a complex task. And we're slowly, I think, getting, because the rush of things coming out is slowly decreasing, we're getting slightly more abreast of it and slightly more in a position to give slightly more definitive answers. But I've said slightly about 15 times in the last sentence, which shows we're not quite there yet. Steve, I'm quite aware that people are beginning to have to go, and we're also knocking on 4 o'clock. Is there anything else you wanted to say before Sam comes in and tells us to stop?
There's one I must touch on, because I think it's a brilliant question, which is the one that's coming at 3:47, about those who are deaf and blind, and what happens in that situation where they need physical touch to communicate. Well, that has to be a brilliant example of where exceptions and reasonable adjustments will need to be made. I'm not saying that everything goes out of the window in those cases, because unfortunately people who are deafblind can get coronavirus, same as everybody else, and can spread it. But if you need to be touched in order to navigate the world, then that has to be taken very significantly into account in deciding how your care is going to be provided, how you're going to access the community, and so on. So no sort of straightforward answer to that question, but it's a great illustration of a major theme of our joint talk, I think, Alex, which is careful individualized decision making and balance. The essence of all of the qualified convention rights, including Article 8, is balance. It's balancing up different considerations and weighing those factors appropriately in any particular case. And there's, again, nothing that's happened as a result of the pandemic has changed any of that. So that's my last thought, is the need to people to keep striving for an appropriate balance.
Okay, thank you both very much. You have just stolen my summing up, Steve.
Oh, sorry.
No, it's okay. It's okay. But I was absolutely going to say thank you both so much. What I have heard for the last hour and a bit is about balance and consideration and creativity and reasonableness, I think, and looking at all of the law, the guidance. So I've found it incredibly helpful. I know from some of the comments in the chat, lots of other people have. Thank you both very much. We have recorded it. So as soon as I get it to render, which last time took me a long time, we will share it with everybody. But thank you all very much, and we really appreciate it. And thank you, Steve and Alex. It's just great. Really, really helpful.
Thank you very much.
Help us all work our way through this strange and unusual time.
Absolutely. Keep going, everyone. And thanks for the excellent questions.
Yeah,
absolutely, I agree. Thank you.
Cheers all.